Katherine Kallergis, we're going to go to you with story number 2. This is a piece that you wrote. It appeared in The Real Deal. I'll read you the headline, first couple graphs on it. Any kind of insight you can provide. You might not be able to comment because you wrote about the story, but any insight you could share with the audience would be greatly appreciated. So here we go. Again, Real Deal. Headline in quotes, even more difficult. And here's how South Florida's condo buyout landscape will shift following landmark ruling. And a buyout basically is a situation where you take a condominium, you file the paperwork, and lo and behold, that condominium where you have individual unit owners suddenly reverts to one owner and it becomes effectively an apartment building. It's a declarative condominium. It's handled by the state of Florida. The state of Florida notifies the local property appraiser, and that's what differentiates a condominium from a rental, this declaration of condominium. So going back to your headline, Katherine, even more difficult in quotes. Here's how South Florida's condo buyout landscape will shift following landmark ruling. And here's a subhead. Condo associations may have to secure buy-in from majority or all unit owners before developers will consider these deals, insiders say. And first couple graphs, the developer of the planned addition residence in Miami's Edgewater is on an unforeseen footing after recent rulings that could cost it millions of dollars and alter the landscape of future condo buyouts and terminations statewide. Two Roads, a Miami and West Palm Beach-based development firm led by Reed Boren and Taylor Collins, completed a bulk $150 million purchase on Biscayne 21, a 13-story, 192-unit building at 2121 North Bayshore Drive in 2022. But the developer's plans to demolish the building and construct the new addition tower is now in limbo after Florida's Third Circuit Court of Appeals this month found that the Biscayne 21 condo declaration gave every unit owner an effective veto over any termination of the association. The appeal court reversed the lower court decision that had denied the plaintiffs, a handful of holdout unit owners, a temporary injunction in their lawsuit against Two Roads Development. Unit owner suit alleges that the developer illegally amended the condo declaration. Wow, Katherine, this could have seismic effects on what's going on in Florida right now with condo buyouts, with terminations, and the looming 2025 deadline where associations have to do their structural integrity studies and then carve out money in the budget in 2025 to actually pay for it. So what can you tell us about it, Katherine?
Yeah, I think what's kind of interesting is this only applies to condo associations where in the declaration, it explicitly said that it required 100% approval to terminate. And it was before the law changed, I think in 1974, I want to say.
Okay.
So, it obviously doesn't mean all buildings, but because it applies to buildings that are generally much older, it's probably the ones that developers are targeting. So essentially, it's hard to get enough buy-in to do these deals anyway. Now developers are probably not going to want to touch those buildings unless they get 100% approval. So it just really kind of muddles up that process, but it gives the unit owners more power in blocking a deal and staying in their units. Then you have all the issues that we just talked about with the previous story. All these buildings are much older. They need a lot of, they need more repairs. They're more expensive to maintain. So I think it just makes these deals more challenging. But also the developers, without revealing too much, are trying to fight this. So stay tuned on that.
And Katherine, I wonder, when you were reporting out the story, did the developers say anything as how do they go forward?
What's unusual, I think, about this deal is that the developer closed on the majority of units, paid $150 million for them. Those owners are gone. They've gotten their money. That's done. They started pre-sales for their, over a year ago, pre-sales for their branded luxury condo project. So they're that's what I mean in the story by they're on unforeseen footing or whatever words I use. But it's essentially, I think if they don't get a rehearing, because there's no, the third DCA is kind of the final thing unless you go to the Supreme Court. So if they don't get a rehearing, they would try to get the Supreme Court to hear it. That's hard to do. They get, I don't know how many requests. So I think they'll probably try to settle with the remaining owners just so they can move on. Otherwise, I don't really see what other option they have. But I'm not getting any indication from either side that there is a settlement at this point.
Interesting. Let me throw this out to John or to Mr. Fakler. John or Mr. Fakler, typically if you have a house and the house is in disrepair, the city will notify you and then lo and behold, they'll send in a bulldozer and knock the damn thing down. And then they'll give you the bill. They'll lean it against your property, whatever the case may be. You're still the owner, but they'll lean it against there. Maybe they'll try to sell the property, get repaid, whatever the case may be. I'm not an expert in that, but just talking big picture. So, gentlemen, I'm just wondering if the supermajority of these units were sold to this one developer, which is called, it's called Two Roads, and they decide come 2025 that they don't want to put any money in reserves and could be torn down for safety reasons. I mean, could you see that as a strategy?
I don't know. That's like, there's a lot of hypotheticals in there. I mean, I think the easy way to solve it is what Catherine said, which is you pay the remaining owners more. You pay them to get out. So, I mean, it's pretty simple. I mean, that everybody's got a price. And I'm sure the remaining owners have a price. And that's probably why they held out. And my guess is, I don't know, but my guess is they're holding out for more money. So, and of course, with this looming deadline and all these fees, and requirements, I mean, everybody's got to come to some sort of an agreement here, because it doesn't make any sense for them to stay. And, the developers just need to pay in a little more and have them go away.
So, Mr. Fakler, let me ask you, if you were somebody, and Catherine mentioned in her story that pre-sales began about a year ago or so. Now there's some question about whether or not this project's going to go forward in terms of the timing. I'm just wondering, Mr. Fakler, if you were somebody who put down cash more than a year ago, now you're reading this headline, you got your cash down. Now, granted, I don't know what percentage of the cash was put down, but it's the addition, so it's a name brand. What would you do if that were you, Mr. Fakler?
Well, and let's point out it's probably a large amount of cash, because these are name brands. The part of this whole deal starting years ago with the cash down was you got to put a certain amount of cash down. And I don't know what the number is here, but if I put a lot of cash down in this, I would be livid. I don't know, what are you going to do? You're trapped. You're going to be tied up in litigation if you fight it. You would probably have to, like Jean said, hold out for the most money you could possibly get, because you're stuck. I mean,
or just to throw it out there to the floor, or what you do is if this Two Roads group actually acquired a super majority of the units, but not enough to get over the one vote veto, why not just jack up the budget in 2025? Because obviously you can vote in whoever you want, make it so cost prohibitive that anybody who's living there, then you can move the foreclose on them for not paying the maintenance fees. Or John, is that too many hypotheticals?
Well, there's just a simple way out, which is you just pay the owners more. But obviously that may not be in their budget, but it seems that they lost in court. So they gotta come to a settlement.
yeah.
I will say, not to throw a wrench in the hypothetical, but the building is empty.
Please.
So the AC stopped working last summer. Everybody was out. So there's nobody actually. I don't even think it's livable at this point.
Wow.
Mr. Fakler, is that a shakedown? Well, the fact that these people simply don't want to turn it over. They can't live there. They're not living there anymore. So I'm wondering, do you think these people simply think they can squeak a little bit more out of this greedy, rich develover, which is the way many of them probably see it?
Absolutely.
Awesome. Good.
Hey, one more question. You mentioned the pre-sales. Now, if you put cash down for a future unit, doesn't the developer have to perform in a specific amount of time? And is there like an out for those folks who've put down deposits for the units?
They do.
Well, usually there is, right? I mean, I've heard that.
Yeah, don't you think, Peter? That's what I've heard.
Well, I can discuss this. I don't want to do it on the podcast though, because there's going to be a bunch of attorneys. I don't want to give any kind of legal advice because I am not an attorney. But there is an avenue, a vehicle that many developers use to go ahead and peddle product. So yeah, there are some nuances involved with it, is all I'll say. But I'm not an attorney. I'm not practicing law. Check with your attorney.
Thanks, Peter.
You were talking hypotheticals.
Thanks. Yeah. Thanks for not putting us in legal jeopardy.
Exactly.
And if anybody out there is threatening to sue Mr. Fakler, can be reached on X, which is formerly Twitter, at JT Fakler, JTFAKLER. All right,
You set me up for that. That question set me up. I didn't realize it.